And the third element in negligence is damage. Okay, so you have your duty, you've got your standard, then you've got the damage. Okay, and then basically, if there's no damage at all, then basically there's nothing to do, there's nothing to claim, there's nothing to sue for. The claimant must prove that their damage is caused by the defendant's breach of duty, and that damage is not too remote. So these two elements, if we say that, is there really a damage suffered, then there's two things that you need to look into. Okay, number one, for the first part of it is actually the damage is caused by the breaching of duty, and then the damage is not too remote. One is called causation in fact, and the other one is called, the remoteness is called causation in law. So causation in fact basically is about the event, the chain of event of this thing happening, you see. And that basically it is proven, you have to use the but-for test. It's like the factual, all the facts of how things happen, it would not have happened but for this breach of duty. So that word but for. So the purpose of this is to remove some irrelevant cases. Basically, sometimes some people are being unreasonable, you see. So if these events that happen, you see, and the things that happen and finally it caused that damage, it must be really, basically it must be from that breach. You see, that damage must be from the breach. So any damage with injuries, and then the injuries will also cause some form of monetary loss. And of course, there's also pure economic loss. There's no injuries, but pure economic losses. Also, I mean, it's a bit hard to move into court with that, but it is not impossible. Like I said, it's always case by case basis. There is no acts or anything like that that says that lays down the regulation for the law. Therefore, everything is a case by case basis. So then the case by case basis, there's two elements here, whereby one party needs to make their effort to prove, the other party needs to make their efforts to defend. You see? So, and when we talk about damage, the claimant must prove that if it's not for this guy not doing this thing, or it's not for this engineer not doing this thing, or this architect not doing this thing, or it's not for this driver being so careless, that this would not have happened. So this is the but-for test, okay? Then related to the remoteness of the case is about, again, that relationship between the defendant, you see, and the claimants. So usually we will apply the foreseeability, reasonable foreseeabilities situation. So the event, the damage must be reasonably be able to be foreseeable. So if you don't do this, sure this will collapse, sure this will have problems, sure the wall will crack. And if the wall crack or if the wall collapse, then what happens? So if you kind of know that it will happen, or maybe suspect that it will happen, or thinking about the risk of this happening, then this is, you are already doing that direct consequence test to test the remoteness. So the remoteness test is basically like the what we call whether it will the damage will actually happen or not. You see, so yeah, the test of remorse is actually kind of damage suffer is reasonably foreseeable or not. So this is something that we have to answer when we talk about damage. This damage again boils back to that duty. It goes back to that foreseeability. It goes back to the, if it's not for you, I would still be, in one piece, that kind of element here. But there's a few principles regarding remoteness, even if it's foreseeable. If the kind of damage suffered is reasonably foreseeable, it does not matter that the damage come about in an unforeseeable way. So it does not mean that, okay, let's say there's an example here. So you accidentally set a fire, and then some damage was caused. But then in between there was this wind that really blow the like, let's say your house is on fire, and then the neighbor's house got caught fire, and then the wind was the one that blows it into the direction. It does not mean that, it does not mean that causation is break, like the factual causation is broken, you see. So it is still, you have set the event, and even the way that it comes about, to your house, to the claimant's house, is still considered as reasonable in that sense. So yeah, and then provided the kind of damage is foreseeable, it does not matter that it's extensive. The extent of it is more extensive than foreseen, you see. So it doesn't matter. So then these are the few foundation that we are working on. And again, like I said, we don't really have a system. I mean, this is like a few rules and principles that we have to establish. Then, of course, from the defendant's perspective, you have to prove that it is, there's a period of proving that you don't have that duty, or you don't have that breaching in that sense. And so is this a good defense? Is this so the defendant's breach of duty may cause damage to the claimant that satisfy the but-for test, but in some factual cause, intervening after breach may be regarded as a sole cause of some and all the damage claimant's damage. Where this happened, intervening cause is known as novus actus intervenens, and break the chain of causation between the defendant and claimant. So again, natural event is not a good defense. You cannot say that, because the wind blows and therefore my property caught. You see, an intervention by third party. There's like this happened, but then some other third party came into the picture and create more damage, in that sense, you can say that, it's because the third party did it, so it does not relieve the defendant from the consequences of the negligence. Okay. Yeah, so even if there's a third party that comes in and make it even more serious, for example, or causes the direction to change to that particular claimant, but it happens, but it still does not get rid of, basically it doesn't get rid of the responsibilities. And and then the other one, act of the claimant. So it means that in a situation where the claimant's conduct also comes into question, they're normally concerned with contributory negligence, where claimant has been found to contribute to the negligence as well, and the damage will be reduced by proportion. And this all has to be proven to that. And defense to negligence can be looked at in three manners: voluntarily, agreement, knowledge, contributory negligence. So this is all talking about defense of negligence. And you're defending, it's caused by somebody else, or I don't know about this, or I'm not sure about this. So the claimant must have knowledge. They must have enough knowledge to make a claim in that sense. They cannot go into this because somebody tells them to do it, and sort of thing. So it must be voluntarily. There must be the claimant voluntarily assume the risk of harm. So it's saying that that he knows when this happens, he knows that I am put at risk. You see, so basically these elements here, you just have to read it through, I mean, I think it's quite understandable, quite easy to be understood. So this contributory negligence and also voluntary, we call it voluntary non-fit injury. Because if there's no injury to a willing person, is one of them. It means that the claimant voluntarily agree to undertake legal risk of the harm at his own expenses. So meaning that once you claim already, once you start to make a claim already, you're already taking up the risk. You're actually acknowledging that I am being harmed. That kind of is that kind of matter, okay? And yeah, so if there's any issues later on that comes back to bite you, you cannot say that I don't know about it. That is what we're saying. And yeah, I think the next bit here we'll be talking about statute vicarious and strict liability. Okay,